Hi, class. Welcome back. This is Professor Watson. Contracts, LGLA 1351, just so you make sure you're in the right place. This is week 6, and so we are on chapter 5. We're talking about consideration this week, and this is our second recording for the week. Okay, this is a long chapter, and consideration is an important topic, and it can be complicated, right? I gave you my definition. The best definition I can offer you is that consideration is what you give for what you get, right? That recognizes that both parties have to give something, both parties have to get something. There has to be an exchange. Otherwise, it's not a contract, right? If only one party is giving something, only one party is getting something, that's a gift, right? That's just a gift. We did, though, start to talk about what can be consideration. Well, just about anything, but it has to be real. And that got us into a conversation about illusory consideration, right? What consideration is real? Is a promise to love somebody real? Well, we can debate whether love is real or not, but a court can't enforce love. A court can't measure love. It's not objectively verifiable. A court can't say, yes, you did love them, so you did your part of the contract, or no, you didn't love them, so you breached the contract, right? A court can't say, well, you contracted to love them, so now you have to. I'm going to make you do it. There's not a way for a court to do that. So a promise to love somebody is not valid consideration, right? That's not going to support a contract. But we talked about things like conditional contracts, that sometimes just because the contract is conditional doesn't make it illusory. So your insurance company, right? You're not going to be able to sue your insurance company to get all your money back, even if you never had a wreck. They made you a promise. That promise was objectively verifiable and it was enforceable. If you had a wreck, then they would pay. And if you had a wreck and they didn't, the court could force them to pay. But the court can also tell whether or not you had a wreck, right? Here's my wrecked car. There's somebody T-boned me in the intersection, right? Now they have to pay. That's objectively verifiable. We talked about a number of different kinds of contracts, conditional contracts, specific types of contracts that maybe you need to be aware of because maybe you weren't familiar with them before. Things like needs contracts or output contracts, where I promise to buy everything I need from you if I buy any, right? Doesn't obligate me to buy any. Maybe I don't, but that's not an illusory promise because if I buy anything, I have to buy it from you. So I've made an enforceable promise. Or an output contract. I may not manufacture it, but if I do, then I have to sell it to you for this price, right? That's not illusory because it's objectively verifiable. If I produce anything, then I have to sell it to you. An output contract. We talked about an exclusive dealings contract, right? Where two people say, we may or may not do business, but if we do, I'm only doing it with you, right? We're only doing it with each other. That's an exclusive dealings contract. We talked about cost plus contracts. Those can insulate the parties from the risks of inflation without inflating the price of the contract unnecessarily, right? So a cost plus contract where we agree that, look, we can't fix a price here at the beginning of the contract. So instead of saying, I'll do it for $1 million, or I'll do it for $10, or I'll do it for, 50 gazillion dollars. We say, I'm going to do the contract. I'll complete the task, and the contract price will be my cost plus whatever we agree on as my profit, right? So my cost plus 10%, my cost plus 2%. It can be a fixed amount, my cost plus $100, right? Then you have to pay me whatever my costs were plus $100. Even though we can't determine exactly what that amount is going to be at the beginning of the contract, we nonetheless have consideration. We nonetheless have an enforceable promise because it's based on objectively verifiable facts, right? When we get to the end of this, show me your receipts and I'll pay you that plus whatever the agreed profit was, whatever that plus amount was. And that's objectively verifiable. The courts can enforce that. We talked about an allowance contract, right? That's usually a part of a contract. That's where you work in a term that, I'm going to build your house for $100,000. You're going to pay me $100,000 to buy a house. But we have some terms that aren't completely clear yet. Like what kind of bathroom fixtures am I going to put in the house? Well, we haven't decided that yet. We're going to use whichever bathroom fixtures you like, whichever ones you pick in the future. Well, that's arbitrary, right? That's subjective. How is the court going to know? Well, because we put a cap on it, right? It's whichever ones you pick up to $1,000, up to $5,000. And so as long as the ones you pick are within that price range, well, then we still have a contract. That's a conditional contract that's enforceable with an allowance term. And then lastly, we talked about incentive contracts. Incentive contracts, I love those because that encourages people to do a really good job because it's in their best interest. If they do a good job, if they do it faster or better, then they get paid more, right? And so even though we don't know exactly what the price is going to be at the beginning of the contract, it's not illusory because it's based on an objectively verifiable fact. If the contractor finishes the bridge 2 months early, then you owe them the contract price plus the bonus for 2 months, right? Then we just do the math. It's objectively verifiable. So not illusory. Those are kind of special kinds of contracts that maybe you hadn't thought about before. If you haven't been in business, or maybe if you hadn't had experience in multiple different industries. And so if you run into one of those, I don't want the first thing you think, oh, well, this is illusory consideration. This isn't enforceable. No, you got to look more carefully and see, is this promise enforceable? Is there a way that the court can determine it from the facts, even if those facts don't occur into the future? All right. Let's get us back up to our PowerPoint and let's move on to the next topic, which is the bargain, right? Bargained for. Here we go. So we talked about that consideration could be nearly anything. It could be even a peppercorn, as long as you give something and get something, as long as I get something and give something. Then consideration can be almost anything. But it has to be the consideration that was bargained for. Okay, it has to be the consideration that we agreed to, that I wanted, right, in the beginning. It means that whatever consideration each party is to receive, whichever consideration each party is to give, it has to be something that number one, that they asked for and sought, and number two, something that they weren't already entitled to get. Okay, if they were already entitled to it, if it already belonged to them, then they're not really bargaining for it. They already have it, right? At the same time, you can't just give them whatever you want. You have to give them what you agreed to in the first place. You have to give them what they bargained for, what they contracted for, okay? Again, each party has to give something to get something. But that means they have to give and get something as a result of this contract. It has to be bargained for. Past consideration, something that has already been done or already been given, is not sufficient consideration because it's not bargained for, right? You already got it. A pre-existing obligation is not enough to be consideration because that's not something you bargained for. You were already owed that, okay? If we have an example, your neighbor's always been a good guy, right? And he bought a new power washer. And so he did his driveway and his sidewalk. And while he was out there anyway, you asked him if he would go ahead and do your sidewalk too. And so he came over and power washed your sidewalk, and he did a great job. And then after he power washed your sidewalk, you said, you know what? You did such a good job. I'm going to pay you $100. Is that an enforceable contract? No, that's just a gift. You didn't enter into a contract. He didn't promise to power wash your sidewalk in exchange for $100. He just did it. And once it was done, then you promised to pay $100. It wasn't bargained for. He didn't power wash your sidewalk in exchange for something. There was no bargain before he did it. He had already done it by the time you offered to pay. It wasn't bargained for. And so if you promise to pay him $100 after the fact and then you don't pay him and he tries to sue you for breach of contract, you can say, you know what, there's no contract because there was no consideration. I was going to give something. I was going to give $100, but I wasn't getting anything. And he says, yeah, you did. You got your sidewalk power wash. You say, no, I already had that, right? You already did that before we entered into this bargain. It wasn't bargained for. Likewise, a pre-existing obligation, not good enough, right? If you had entered into a contract with him to power wash your sidewalk for $100, and you guys shook hands on it. Okay, I promise to pay you $100 if you power wash my sidewalk. Okay, I promise to power wash your sidewalk for $100. Well, now you have an enforceable contract. And if he comes to you and says, "Hey, you know what? Before I get started, I was kind of rethinking this. I'm not sure I really want to do this. So I tell you what, I'll power wash your sidewalk for $200." And you say, "Well, wow, it kind of feels like you're scamming me here, but I was really looking forward to that. So okay, I'll pay you $200 to power wash my sidewalk." So then he power washes your sidewalk, and you pay him $100. And he says, "Wait a minute, you promised to pay 200," and he sues you for breach of contract. Is he going to win? No, because your contract, power wash the sidewalk for $200, did not contain a bargain for exchange. You weren't getting anything new. He was getting an extra $100, but you weren't getting anything. You already owned the obligation for him to power wash, right? So a pre-existing obligation, not enough. All right. What about when the beneficiary is a third party, right? Or what if you owed the obligation to someone else? Let me give you an example. I've already promised my dad that I'd quit smoking in exchange for $100. Is that consideration? Sure. I'm getting $100. I'm giving a promise to quit smoking. What's my dad getting? He's giving $100, but is he getting anything? Sure. He's getting my promise to quit smoking. What is that worth to him? I don't know. Doesn't matter. That's that peppercorn. Is he getting what he bargained for? He got my promise to quit smoking. So yeah, that's consideration. Now, let's say my grandmother also comes to me to make the same offer. My grandmother says, "I'll pay you $100 if you quit smoking." Can I make that offer with her? Is she really getting anything? Or is that a pre-existing obligation? No, in that situation, she is getting something. She's getting an enforceable promise. If she didn't pay me the $100 and I didn't quit smoking, then she couldn't sue me, right? I didn't make her any promises. I only made dad the promise. But if she pays me the $100 too, she's getting something. She's getting an enforceable promise that she too can enforce. Maybe that smoking example is a little weird. Let me give you another one. I have promised to teach this class to 20 students, right? And in exchange, you all agreed to pay tuition to the school. And then after we enter into that contract, they add 5 more students. Well, I was already obligated to teach the class, and you guys were already obligated to pay for it. What about these 5 extra guys? Are those contracts supported by consideration? I was already obligated to teach the class. The answer is yeah, because I wasn't obligated to teach the class to them. They didn't have a promise that they could enforce until they entered into a new contract and paid their tuition, right? Before they entered into that contract, if I didn't teach the class, you all could sue me, and you could force me to do it. But they couldn't sue me and force me to do it because they didn't have a contract. All right. So an existing obligation to a third party doesn't mean it's an existing obligation to you. And so an existing obligation to a third party, that may still be sufficient to support a new contract with you. But be careful. Be careful, because sometimes in some situations, in some jurisdictions, you can come up with a crazy fact scenario where the result may be a little bit different. Okay, so check your jurisdiction, check your common law just to be sure. All right. Modification of an existing contract. This is an extremely important subject when it comes to consideration. All right. We're gonna see our old friend, the Uniform Commercial Code, again. Remember, we talked about that in general, the common law controls, unless it is supplanted by a statute. The granddaddy of all those statutes when it comes to contracts is the Uniform Commercial Code. And so as we go along this semester, we're going to talk about where the law under the common law may be different than the law under the UCC. Now, the UCC doesn't always apply, right? It only applies to sales contracts. At least Article 2 only applies to sales contracts by or between merchants. So you got to have at least one merchant involved. It has to be for the sale of goods. And if the UCC applies, the law may be a little bit different. So let's talk about the common law on modification of existing contracts and what that has to do with consideration. All right. So in common law said that every contract had to be supported by consideration, right? That's the rule. We already know that one. But the common law treated a modification of a contract, an attempt to amend a contract, as a whole new contract. And that whole new contract then had to be supported by consideration. So think of it this way: if we've already got an existing contract, then a modification is just a contract to change the old contract. Okay, so it's a new contract. As a result, at common law, every attempt to modify a contract, right, after the contract has been established, right? This is an attempt after we've already entered into a contract, after we've reached an agreement. Now, if we want to modify the contract, well, the common law treats that as a new contract, and it needs independent consideration. This is where some of those concepts like past obligation, things that you were already owed, or past obligations or past consideration is not consideration for a new promise. Let me give you an example. I guess let me back up. What I'm saying here is that if you want to modify a contract, that modification has to be supported by independent consideration. And remember that consideration is what you give for what you get, and both sides have to both give and get something. So if you want to amend a contract, if you want to modify a contract, then both sides have to give something new and both sides have to get something new. All right, now let me give you an example. So let's say that the seller contracts to deliver a new car on Friday if the buyer pays $20,000 today. So the buyer pays on Thursday. So the buyer pays up now. He pays his $20,000. But on Thursday, the seller calls and says, you know what? That car we were getting in, it's actually more expensive than I thought. And so I'm not going to deliver the car to you unless you agree to pay another $2,000. All right. And now the buyer really wants the car, and so he agrees to pay the extra $2,000. Do we have a modification of the contract? Do we have a valid, enforceable modification of the contract? The answer under the common law is no. No, because the seller already had an existing obligation to deliver the car on Friday, right? The buyer was already entitled to receive a car on Friday. So this attempt to modify the contract, where I'm going to give you an extra $2,000, a buyer is going to give the seller an extra $2,000, but the seller is not delivering anything new. Buyer is not getting anything additional, right? The promise to pay the extra $2,000 is not supported by independent consideration. And as a result, that modification is not enforceable. It is an unenforceable promise to make a gift. So what would happen? So the buyer could say, okay, I promise to pay the extra $2,000. And then they go get the car and they say, you know what? I'm not paying the extra $2,000. Bye. If the seller tries to sue for the extra $2,000 and say, well, you agreed to pay an extra $2,000. Remember, you could say, sorry, that agreement to pay the extra $2,000 wasn't supported by independent consideration. All right. The seller was giving something new. He was giving an extra $2,000, but he wasn't getting anything new. He was getting the same obligation that he already had. So that agreement after the fact to add an extra $2,000 to the contract price, not going to be enforceable under the common law. Is there something the parties could have done to make the contract, to make the modification enforceable? Absolutely. And here is my best advice for you. If you're going to attempt to modify a contract, always make sure that there is new consideration on both sides. All right. And remember that consideration can be anything. It can be even a peppercorn as long as it's new. All right. So what if when the seller said, hey, I'm going to need an extra $2,000, but if you'll pay the extra $2,000, I'll throw in 1 year worth of oil changes for free. Now, would that modification be enforceable? Absolutely, because now the buyer is giving an extra $2,000 that he wasn't obligated to give before, but he's getting a year's worth of free oil changes that he was not entitled to before. The seller is getting an extra $2,000, but they're giving a year's worth of oil changes that they weren't obligated to give before. So in that situation, the modification would be enforceable. Does the consideration have to be as significant as a year's worth of oil changes? No. Remember, the court's not going to measure, it's not going to weigh consideration to see if it's sufficient. The court's only going to look at, did you get the consideration that you bargained for? So what if the seller had called and said, you know what, I can't deliver it for $20,000. I'm going to need an extra $2,000, but if you'll pay the extra $2,000, I'm going to throw in a really nice calendar from our car dealership, right? If the buyer agrees, then do we have a valid modification of a contract? Yes, because because it's supported by consideration on both sides. Now, you may not think that the consideration is worth it, $2,000 for some cheap marketing catalog. But it's not up to the courts. The court's not going to weigh consideration to say if it's sufficient. It's just going to weigh and see if you got what you bargained for. And in that situation, both sides are giving something new. Both sides are getting something new. So if you need to modify a contract, make sure that there is some new independent consideration on both sides. If you don't, then what you have is, at least under the common law is going to treat that modification as a new contract. And if you only have promises going one way, the court's going to say no consideration, right? That modification is not a binding enforceable contract because it's not supported by independent consideration going both ways. That's an important lesson. Just remember, add something new. It doesn't matter what it is. It can be fairly small. It can be a peppercorn, but as long as you make sure you're adding something new both ways, then a court should find that modification is enforceable. All right. Brings us to the topic, an interesting topic of something called an accord and satisfaction. Okay, an accord and satisfaction. An accord and satisfaction is a mutual agreement to accept or give payment or performance that is different from what was originally required, right? That's the accord. We've agreed to do something different, and the satisfaction is where you actually do the something different. And that is recognized in the law because it happens all the time, right? But there still has to be some new consideration going both ways. The consideration is not always money. It's not always property. It could be the granting or releasing of a legal right. So let me give you an example. Well, let's go back to the car, right? I promised to sell you a car for $20,000. You pay me the $20,000, and before the car comes in, I say, hey, I'm going to need an extra $2,000. And you say no. And so you sue me, right? And you sue me, and as a result, we reach an agreement. We reach an agreement that you'll pay me $21,000 and I'll deliver the car. How is that different from what we had before? Well, in this situation, there's a chance that a court would call that an accord and satisfaction. Even though it looks like all we've done is raise the price, we've agreed to that because we've got a legal dispute now, right? What you're really getting is yes, I'm getting $1,000 and you're just getting the same old car, but I'm getting an extra $1,000 and you're finally getting the car, right? I didn't deliver it, and so you had to sue me, and you're getting out of that lawsuit. if the parties agree to that, should the court encourage settlement agreements? Sure. And those settlement agreements don't always look like they're supported by independent consideration on both sides. And so as a result, we have this concept of accord and satisfaction, right? Or let's kind of reverse the order there. Let's say I delivered the car and you promised to pay me $20,000. You've already got the car. But the time comes up for payment and you come to me and you say, man, I don't have $20,000. I've got 18. And if you want the money now, I'll give you the $18,000, but you have to release the rest. And I say, okay, and you pay me the $18,000, and then I sue you for the extra $2,000. Normally at common law, the court's going to look at that and say, no, you still owe the $2,000 because that attempt to modify the agreement was not supported by consideration. You got basically $2,000 off. But the seller didn't get anything. He just got $2,000 less, right? So that's not supported by independent consideration. That modification is not enforceable, and the seller could still sue for the extra $2,000. But what if now that there's a legitimate dispute, the seller doesn't want to have to sue you for the $2,000, right? Lawyers are expensive. Courts are expensive. And so you guys finally reach an agreement. Your lawyer calls their lawyer, and before you file suit, they say, okay, we'll agree to accept $19,000. Is that enforceable? Well, again, that may look just the same. The seller is just getting less. He's not getting anything. The buyer is getting $1,000 off. Would that be enforceable? And the answer is yes, because a court may, it may be enforceable. The court may look at that and go, okay, I see what you're saying, that's not supported by independent consideration here. But what we have is an accord and a satisfaction. We have agreeing not to sue each other, basically, right? Or negotiating this disputed right. And so the court finds that that's an enforceable accord and satisfaction. Now, that may sound fishy to you, and that may seem confusing and hard to understand. And if that is the case, then good, okay, good, because it happens all the time. And then sometimes people sue on these things that one party wants to call it accord and satisfaction, and the other party wants to say, no, that's just an invalid attempt to modify a contract that's not supported by independent consideration. Who's right? And the answer is, I don't know. The court may go one way or it may go the other, and it could be just as confusing to the court as it is to you right now. So what on earth can you do in those situations? Sometimes you have those legitimate situations, right? I can't pay the full $20,000, but you would really like to have at least the $19,000 right now. And I'm not going to give you the $19,000 unless you agree to accept it and release me. I'm not going to give you the $19,000 and then let you sue me anyway. So what can we do? How can we be sure the court is going to say, yes, this is a valid accord and satisfaction, and not, no, this is an invalid attempt to modify the contract? Well, my advice to you is to go back to what I told you just a few minutes ago. If you're going to attempt to modify the contract, include something new. Even if it's a settlement agreement, even if the new thing you're adding seems fairly small, right? Even if you're a lawyer or a legal professional who's negotiating a settlement deal, make sure you're adding something new. If you've already filed a lawsuit, then maybe what you're getting is a release of the lawsuit. If you haven't filed the lawsuit, maybe the extra thing is an agreement not to sue. But it could also just be, remember, throw in that calendar, throw in that free oil change, throw in a Subway sandwiches punch card that only has 3 punches left, right? That's something new in exchange for the money off. So accord and satisfactions can be confusing. They can even be confusing to the court, and you can't ever be quite sure which way the court's going to go. Whether the court's going to say this is a valid accord and satisfaction, this is a valid, attempt to make a modification to a disputed contract, or whether the court's just going to say, nope, that's an invalid attempt to modify it. All you did was agree to pay less. And so my advice is don't leave it up to the court. Add something new, even if it's small, so that you can make sure both sides are getting something, and so that you can make sure that modification, or you can make sure that that settlement, that accord and satisfaction is going to be enforceable. All right. I have seen a lot of settlement contracts fall through, and for exactly this reason. Make sure that if you're agreeing to accept less, that you give the other side something extra to make sure that that settlement agreement is enforceable, that there's not some question about was it a valid accord and satisfaction or an invalid attempt to modify a contract. All right. The UCC treats modification of a contract differently. All right. So the basic rule, the black letter rule under the common law, is that every modification of a contract must be supported by independent consideration. Right. That's the black letter rule. You can start there. Every modification of a contract is a new contract that must be supported by independent consideration. That is different under the UCC. Again, remember that the UCC is about facilitating commerce and facilitating trade among merchants, among professionals, among people who do this every day and know what they're doing. And remember that the UCC tries to recognize the practicalities of how business is actually done. And it recognizes that sometimes the parties decide that they need to change a contract, that they need to just accept less money in exchange for just getting it done. Okay. And so the UCC treats modification differently. The UCC section 2209 says that an agreement to modify a contract that falls under this chapter, that falls under Article 2, does not need consideration to be binding. Okay. As long as B, it's represented by a signed writing. Okay. A signed agreement that excludes modification or rescission can be changed if there is a signed writing. Okay. Even if your agreement says that it can't be modified, well, you can modify that agreement that it can't be modified. You don't need independent consideration as long as there is a signed writing. All right. So that's the difference between common law and the UCC. The common law, again, requires independent consideration going both ways for every modification of a contract. The UCC does away with that obligation. It says an agreement between the parties, as long as there's an agreement, you don't need independent consideration to modify the contract. In some situations, though, that modification has to be evidenced by a signed writing. This leads us to, I guess we're talking about a little bit more when we talked about accord and satisfaction. I just want to make sure that you all understand, especially if you're going to be a paralegal, if you're going to be a legal professional, if you're going to be working in a law office. Sometimes we get contracts and we're called in to negotiate those contracts at the beginning, right before the contract is entered into. But a lot of times, especially as a trial lawyer like me, we don't get the contracts until after the fact, until something has gone wrong. And now we're left with this mess, right? And we have to also recognize that most cases that get filed don't go to trial, right? Something like 90% of cases, give or take, that get filed never make it to trial. Sometimes that's because the case gets dismissed. Sometimes it's because one of the parties just gives up. But much of the time, it's because the parties reach a settlement agreement. What is a settlement agreement? A settlement agreement is a contract. And so when you're entering into a settlement agreement, sometimes settlement agreements are very different, right? But sometimes those settlement agreements look an awful lot like the original contract, just with one side receiving less. And so the question may pop up, is this just a pre-existing obligation? Am I getting anything in this settlement agreement? Or am I actually receiving something? Sometimes it turns on whether the claim is liquidated or unliquidated. Okay, liquidated or unliquidated. What do we mean by that? when a claim is liquidated, it means that the amount that is owed is already fixed. It's already able to be determined, right? So I sold you my car for $20,000. I gave you the car. You didn't pay me. We know exactly what you owe. You owe $20,000. That amount is liquidated. All right. So if we enter into an agreement where you get to keep the car and just pay me less, then we may have a question about whether or not that's enforceable, right? You've already got the car. You're just paying me less. What am I getting for that, right? I'm getting less money. You get to pay less, but is that supported by independent consideration? I've already delivered the car. Now you say you're going to pay me 18 grand. Well, you were already obligated to pay me 18 grand. In fact, you were obligated to pay me more. So what am I getting for releasing that $2,000? That claim was already liquidated. We knew how much you owed. That might be different from an unliquidated claim, though. Okay, an unliquidated claim is where there is some the amount of the debt is unknown, right? There's some maybe one party thinks they know how much it is, the other party thinks that they know how much it is, but there's some legitimate dispute about how much is owed, right? I mean, if you promise to buy a car from me for $20,000, we know exactly how much is owed, and you can come back later and go, well, I don't think the car was worth $20,000, but it doesn't matter because you agreed to pay 20 grand. We all know exactly how much the amount is. But what if we had a contract where I was going to deliver gravel to you at $100 a ton, and so I showed up. You contracted for 10 tons of gravel at $100 a ton. I owe you $1,000, and I show up and I dump gravel out, and then I send you a bill, and you say, whoa, 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 whoa! I know we agreed to $100 a ton, but you didn't actually deliver 10 tons. You only delivered 9 tons, right? So I agree, maybe I owe you $100 a ton, but I disagree on how much I owe you because we have some kind of legitimate dispute about actually how much was delivered. Okay, well, now in that case, if we enter into a settlement agreement, we're much more likely for that to be enforceable because there was a legitimate dispute about how much was owed. Yes, you think that I owed you $1,000, but I think I only owed you $900. In that situation, if we enter into a settlement agreement, then the agreement to fix the price is something that we're both getting, right? I thought I owed you $800, but I'll agree to $900 just so that we have a fixed price. You thought I owed you $1,000, but we'll agree to $900 in order to fix the price. We've both given up the uncertainty and we've gotten certainty. Okay, in that situation, that kind of settlement agreement is much more likely to be enforceable. So where you have an unliquidated debt, the agreement to fix the price can be sufficient consideration for both parties. All right. Whereas if you have a liquidated debt, a debt where the amount is already known, and you're going to try to enter into a settlement agreement where all you're doing is accepting less, well, you may need to be careful because the court may find, well, that's not supported by consideration. That was a past obligation. It's already fixed. So an attempt to come back after the fact to settle an agreement based on a liquidated debt, better be very careful that you have independent consideration. That's that situation where I've told you my advice is add something new. Even if you're paying less, add something new. Add a calendar, add a pink highlighter, add a free oil change. But add something new when you have that liquidated debt, because otherwise the court may find that modification is not supported by independent consideration. Whereas if you have an unliquidated debt, there's a legitimate dispute about the amount owed, then the agreement to fix the amount may be valid consideration going both ways, right? I agreed to the amount, I got certainty, you agreed to the amount, you got certainty. We both gave certainty, we both got certainty. So liquidated versus an unliquidated debt is the difference between we know how much is owed versus we don't know how much is owed, all right? And that can make a big difference when we're talking about consideration and whether the agreement is supported by consideration. Okay. All right. Some of that can be a little complicated. Some of that takes take some thinking. Some of it can be kind of circular, right? You don't really understand it until you've gone full circle and thought about it all the way around. And I get that. It takes some work. And if we had more time in class, I'd give you some more examples, or I'd let y'all ask questions. We don't have that here because this is a recorded lecture, an asynchronous class. But please give me a call, send me a text, shoot me an email if you have any questions about that, so we can try to go over evaluating when do we have consideration, right? To go all the way back to the beginning, don't groan. Give me 2 minutes and then I'll be done. Go all the way back to the beginning. Remember, consideration is what you give for what you get. That means every contract has to be supported by obligations and benefits going both ways. We both have to get something, but we both also have to give something. Otherwise, it's not consideration. What can that consideration be? It can be almost anything as long as it's not illusory, right? It can be a contract. I'll give you $10,000 if you give my daughter your car. Is that supported by consideration? Have I given something? Yes, I gave $10,000. Have I gotten anything? Let's think about it. Have you given anything? Yes, you gave a car. Have you gotten anything? Yes, you got $10,000. But what about me? I gave $10,000, but did I get anything? Yes, I did. I got your enforceable promise to give my daughter your car. What is that worth to me? I don't have any idea, but it's at least a peppercorn. It's at least something the court can enforce. Why do I want my daughter to have a car? I don't know. Maybe I love her. It doesn't matter. As long as it had some value to me, that's sufficient consideration. All right. But the consideration can't be illusory. It has to be something that the court can enforce. Can the court force you to give your car to my daughter if I pay up? Yes. Can the court force you to think highly of me if I give you $10,000? No way for the court to do that. No way for the court to even measure that to see whether you've complied with the contract. So be careful of the illusory consideration. That can come in real importantly when you're drafting a contract. You're drafting a contract and you're trying to make it so good for your client that you take away, you try to put conditions on anything that they might have to do, right? You make it's so good for your client. They have all the benefits, and the chances of them having to do anything are pretty limited, right? To only if they agree, only if they want to. Well, what you may have done, instead of drafting a very strong contract for your client, you may have just drafted an unenforceable contract because your client isn't giving anything. If you've made all of their obligations conditional, and those conditions aren't based on objectively verifiable facts, you may have just created an unenforceable contract, okay? That's important. It's important that we talked a little bit about different types of contracts. You remember those. It's important to understand the common law rule that modification of a contract, modification of an existing contract, in common law, that's just treated like a new contract, right? We've entered into a contract to change a contract. And that new contract has to be supported by independent consideration. It's not enough just to change the price, right? If you just change the price, then one person's getting something, but the other side isn't, right? If you just change it to a lower price, well, then the buyer's getting a lower price, but the seller's not getting anything. If you just raise the price, the seller's getting something, right? But the buyer's just getting that same old consideration that they were already entitled to. That's not a valid modification of a contract. My suggestion, add something new. Add a pink highlighter, right? I'll give you $20,000. I'll give you $2,000 extra, or you're going to give me $2,000 extra in exchange. I'm going to give you the same car, but plus a pink highlighter. That's consideration. Or I'm going to give you $2,000 less, but I'll give you a pink highlighter, right? That's something different, something new that would support that modification of a contract. Be careful if you're just changing the price and attempting to modify a contract. Leads us to that accord and satisfaction. An accord is an agreement to substitute one performance for another. Satisfaction is the actually doing it. So if I agree to mow your lawn for $10, and we've got an existing contract, right? And I say, you know what, I don't want to mow your lawn, but I'll paint your house for $10. Okay, that's a valid accord and satisfaction. We've modified the contract. You've got something different. Instead of getting your lawn mowed, you got your house painted. And I got something. I got $10 for painting the house. That may be a legitimate accord and satisfaction. But If you sell me your car for $20,000, I've already got the car. And when I show up to pay, I don't have $20,000. I've only got 18. You really want it now. Can we just substitute the agreement to pay 18 in exchange for the agreement to pay 20? Is that a valid accord and satisfaction? And in some cases, you may really want to do that. You wish you had 20, but you need the 18, so you'll take that now. And the guy's only going to give it to you if this is a valid accord and satisfaction. So you got to be careful with those. If it looks too similar, the court might find it's an accord and satisfaction. It might not. My advice to you again, add something new, right? Add a pink highlighter to make sure that both sides are giving and getting something new. We also talked about that the UCC treats it differently under the common law. Every attempt to modify a contract, again, is a new contract that must be supported by independent consideration. Under the UCC says, no. You guys are big boys. So in contracts between merchants, if you want to modify a contract, does not require additional consideration. Just sign a writing. That's good enough. Okay. So that's consideration. That's a lot. I think if you sum that up in one sentence, consideration is what you give for what you get. It's the very best thing I can tell you. It reminds you to always look and make sure that you've got something going to and coming from each side. Because if you don't have consideration. At the end of the semester, we're going to take a look at a big contract, a contract drafted by a whole bunch of lawyers that were charging $600, $800, $1,200 an hour to draft that contract. We're going to look at that confidentiality agreement between Donald Trump and Stephanie Clifford, or Donald Trump and Stormy Daniels was her stage name. And I think what we're going to see when we look at that contract is that Donald Trump's lawyers were real crafty, and they tried real hard to make sure that he didn't have any obligations. And then he didn't sign it. So do we have an enforceable contract? Is there consideration, right? He got something. He got her promise to be quiet. But did he give anything? Because if he didn't give anything, it's not a contract. If he didn't give anything, then it's just an unenforceable gift, an unenforceable promise. All right. We'll talk about that at the end of the semester. I think it'll be really interesting. Otherwise, that's it for this week. Call, text, email if you have any questions. Otherwise, I'll see you next week. Thanks.